17 days. That's how long a set of federally sealed documents sat inside a congressional committee before anyone publicly admitted they were never supposed to be there. 17 days. And in that window, an attorney general got fired, a subpoena got contested, and a protective order signed by a federal judge became, effectively, wallpaper. Here's what I can tell you. This is not a story about political drama. It's not about who liked whom inside the West Wing. It's about a specific sequence of documented legal events, timestamps, case filings, formal letters with hard deadlines that adds up to something the headlines have almost entirely missed. Stay with me. I'm going to walk you through every piece of it. Section 1. The document that started the clock, March 13th. That's the date that matters. That afternoon, the Department of Justice transmitted a production of documents to the House Judiciary Committee as part of an ongoing oversight request. Standard procedure on its surface. Committees request documents, agencies produce them, it happens constantly. Except this production wasn't standard. Buried inside it, on page 3 of a subsequent committee analysis, were materials subject to a standing federal protective order. Not a suggestion, not a guideline. A court order signed by a sitting federal judge explicitly barring those materials from public or third-party disclosure. The DOJ handed them to Congress anyway. Not recklessly, not with intent to expose. The working theory, based on the committee's own written findings, is that the production was automated, a batch transfer that didn't get filtered against the active protective order before it went out the door. That's not a defense. That's an explanation for how a federal agency violated a judge's order by accident and then spent the next 17 days saying nothing about it publicly. Here's what matters. Once those documents entered the congressional record, there was no legal rewind button. Federal rules governing congressional document receipt don't have a standard return mechanism. What Congress receives in official capacity, it tends to keep. The clock started March 13th. Nobody told the public until a formal committee letter surfaced 11 days later. Section 2, the letter with the deadline nobody hit, March 24th, 11 days after the production. Democratic members of the House Judiciary Committee sent a formal written letter to then Attorney General Pam Bondi. The letter was detailed, it was specific, it referenced the March 13th production by date, identified the categories of materials that appeared to violate the protective order, and asked a series of direct questions about how the transmission happened and who authorized it. The deadline written into that letter, March 31st, 5 p.m. That deadline came and went. No response, no acknowledgement, no partial answer with a promise of more to come. Bondi was fired 2 days later, on April 2nd, in circumstances that have been reported widely. The firing itself is not the story here. What matters is the sequencing. The formal deadline for answering documented questions about a violated court order, March 31st. Her last day as Attorney General, April 2nd. The gap between those two dates, 48 hours. That gap is not a coincidence anyone has explained on the record. Section 3. What was actually in the production? Let me be precise here, because this is where the story gets misread. The March 13th document production contained two distinct categories of sensitive material. Understanding the difference between them matters. First category, materials covered by Judge Aileen Cannon's protective order in the classified documents case. These were filings and exhibits from proceedings that had been sealed at the court's direction. Producing them to a third party, including Congress, without court authorization is a direct violation of that order. The committee's March 24th letter identifies this category explicitly and asks whether DOJ sought judicial permission before the production. No answer came. Second category, grand jury material. This is the part that received almost no coverage. Federal Rule of Criminal Procedure 6- governs grand jury secrecy. It is one of the oldest and most strictly enforced rules in the federal system. Grand jury proceedings are secret. Grand jury materials are secret. The list of entities that can receive grand jury disclosures is short, specific, and does not typically include congressional committees receiving documents in oversight capacity without a court order authorizing the disclosure. The March 13th production, according to the committee's own written analysis, included material that fell into this category. Not X, a minor procedural hiccup. Not Y, a paperwork error that fixes itself. This was the DOJ transmitting material that federal statute explicitly restricts to a body that federal statute does not authorize to receive it, without a court order permitting the transfer. That's a serious problem regardless of what the materials actually said. Section 4. The subpoena, and the argument that followed March. House Judiciary Committee votes to subpoena Bondi directly. The vote, 24-19. Bipartisan. Note that number. Bipartisan. In the current congressional environment, bipartisan votes on anything involving the executive branch are rare enough to be significant by themselves. The subpoena compelled Bondi's sworn testimony, personal appearance, deposition format, specific date. April 14th, she didn't show. Acting Attorney General Todd Blanche's office filed a formal response. The argument, the subpoena named Bondi in her capacity as Attorney General. She no longer holds that capacity. Therefore, the subpoena is legally void. It sounds clean? It isn't. The legal precedent on personal subpoenas is fairly settled in the other direction. When Congress subpoenas a named individual, not an office, not a title, but a person, that obligation follows the person. It doesn't dissolve when the person changes jobs, leaves government, or gets fired from the back of a limousine. Former federal prosecutors with experience on both sides of separation of powers disputes have made this point consistently in legal commentary since April 14th. The subpoena argument, as Blanche's office framed it, functions better as a delay mechanism than as a winning legal theory. Within 72 hours of that argument entering the record, 3 Republican members of the Oversight Committee broke publicly with the DOJ's position. Their collective statement, the subpoena stands. That's the tell. When members of the president's own party publicly reject the executive branch's legal argument on a subpoena, the argument isn't as strong as the filing suggests. Section 5. The sealed material still sitting in the record. Here's what nobody is covering properly. The March 13th production, the one containing sealed case materials and grand jury documents, is still inside the congressional record. It hasn't been clawed back. It can't be, through any obvious legal mechanism. What Congress receives in official capacity through a formal oversight production doesn't get returned like a library book. The committee's March 24th letter asks specifically about a January 13, 2023 internal memo included in the production. It asked about an unredacted 11-page filing. It asked about a seating chart that appeared in the production without redaction. Those questions are still technically open. The formal request for the unredacted version of the 11-page filing, unanswered, Bondi was fired before the deadline. Acting AG Blanche has not addressed that specific request in any public filing as of the date of this script, which means a federal judge's sealed case materials, including potentially grand jury documents, are sitting in a House committee file, and the agency that put them there has never formally explained how it happened or confirmed whether it has notified the court whose protective order was violated. That notification matters. When a party to a federal case violates a protective order, even accidentally, standard legal practice requires disclosing that violation to the court. There is no public record of that disclosure having been made. Section 6. The counter-argument. Addressed directly. The loyal to the administration interpretation of these events deserves a serious hearing. Here it is. Bondi didn't personally push a button and transmit sealed documents to Congress. She ran an agency of tens of thousands of employees. Document productions in large oversight requests are processed by career staff, filtered through systems she didn't personally operate. Holding the AG personally responsible for a batch processing failure by a career DOJ attorney working in automated production is, at minimum, a stretch. That's a real argument. It holds up on the facts as far as it goes. The subpoena is void argument isn't purely frivolous either. There is a body of precedent around official capacity subpoenas, and Blanche's legal team isn't making it up entirely. Courts have distinguished between personal and official capacity obligations in related contexts. And the committee's vote, 24-19, while bipartisan, was not overwhelming. Chairman James Comer, the Republican running the committee, didn't vote for the subpoena. That's not irrelevant. Committees take their direction from their chairs, and a chair who didn't support the subpoena is a chair who may not push hard on enforcement. Here's where the counter-argument runs out of road. The March 24th letter didn't ask Bondi to explain what went wrong inside DOJ's processing system. It asked specific questions about authorization. Did anyone at the leadership level review the production before it went out? Was the protective order flagged? Was the court notified after the fact? Those are yes or no questions attached to a legal deadline. The deadline passed. The questions were never answered. That silence isn't procedural noise. That's a choice. Section 7. Why this matters in your zip code. Here's the part that connects to something outside the Beltway. If you have a retirement account, a savings account, or any financial instrument tied to market performance, listen to this part carefully. Federal enforcement stability matters to markets, not politically, mechanically. When the chief law enforcement officer of the United States is fired with an open subpoena on the table, a violated court order in the committee files, and a legal fight over whether congressional oversight authority means anything at all, institutional confidence in the regulatory framework takes a measurable hit. Analysts tracking DOJ enforcement patterns have noted a documented slowdown in financial fraud and antitrust prosecutions over the past quarter. Regulatory slowdowns don't just mean white-collar defendants breathe easier. They mean corporate legal departments start hedging on compliance spending. Enforcement uncertainty gets priced into decisions. That eventually shows up in sectors that affect ordinary investors. Beyond markets. If you've ever been party to a civil case involving sealed or confidential documents, what the DOJ just demonstrated matters to you. A federal agency violated a judge's protective order, faced no immediate judicial consequence, and has not publicly notified the court. If the government can do that with minimal immediate accountability, judges will respond, not by loosening protective orders, but by issuing them more restrictively and monitoring compliance more aggressively. That means longer timelines, higher legal costs, and more friction in civil proceedings. That's not a dramatic prediction. That's how courts respond to demonstrated non-compliance. Section 8. 3 tracks converging on one date. Right now, 3 separate legal tracks are running in parallel. They converge on a single point. Track 1. The subpoena. Bondi's personal attorney is being contacted to set a new deposition date. The committee says the subpoena stands. The DOJ says it's void. No federal judge has ruled on that question yet. Until a judge rules, both sides are technically right inside their own arguments. A ruling resolves it. No ruling keeps the pressure building. Track 2. The sealed documents. The January 13, 2023 memo, the 11-page unredacted filing, and the seating chart remain in the congressional record. The committee's request for the unredacted version of that 11-page filing is still formally open, never answered, and not publicly withdrawn. The court whose protective order was violated has not, in any public record, been notified of the breach. Track 3. The contempt clock. Democratic members have said contempt proceedings become the next step if no deposition date is set. Republican members Nancy Mace and Congressman Roanna sent a joint letter to Chairman Comer urging him to reaffirm the subpoena publicly. Comer said he would talk to Republicans and determine next steps. That was his answer. Not a date, not a commitment, a process. All 3 tracks converge on the moment Comer either schedules a vote on contempt or announces he won't. That decision is coming. Nobody knows when, but the pressure from both sides of the aisle is now formally documented in writing. Section 9. The public statement versus the legal filing. Trump posted on Truth Social, calling Bondi a great American patriot on the same day her firing was being finalized, said she'd done a tremendous job, said she'd be transitioning to an important new role in the private sector. No job was named, no timeline given. The committee record tells a different story. The same week that post went up, the formal questions about the sealed document production, questions addressed to Bondi personally, in writing, with a deadline, were still sitting unanswered. Public statement, tremendous job, beloved colleague, great American. Legal record, unanswered formal questions, violated protective order, missed deposition. See the gap? That gap is not rhetorical. It's documented. It's in the March 24th letter on one side and the Truth Social post on the other. Primary sources, both. They don't match. Section 10. What comes next? And what remains? Open Commerce Secretary Howard Lutnick has a scheduled interview before the House Oversight Committee on May 6th. Bill Gates has a deposition set for June 10th. Pam Bondi's deposition has no confirmed date. Her personal counsel is being contacted. No public timeline exists. The contempt question has no ruling, no vote scheduled, and no public commitment from the committee chairman either way. The court whose protective order was violated has not, in any document available in the public record, been formally notified of the breach. The January 13, 2023 memo remains in the congressional record, partially redacted. The committee's request for the full version, unanswered. Here's where this stands. The sealed documents are in. They can't come out. The subpoena is contested but not dead. The contempt clock is running but not formally started. The court hasn't been told what happened to its order. And somewhere in the middle of all of that, a former attorney general's personal attorney is getting phone calls about a deposition date that hasn't been set. 17 days was how long those documents sat in the committee before anyone said anything. The next 17 days may determine whether anyone is ever formally held to account for how they got there.